All right, thanks everybody. So I'm super excited to moderate this next panel. My name is Aniket. I'm a research fellow at the NYU Information Law Institute, and I have an email address now, so I think I can officially say I'm also an associate professor of law at Fordham Law School. Super excited to moderate this panel on data privacy and generative AI. We're going to kind of launch right into it. So each of our speakers will take 8 to 10, however long you want, minutes to kind of introduce themselves, have some comments on this topic. Then we'll have a little bit of kind of discussion among the panelists and probably 10, 15 minutes at the end for audience questions. So with that, let's get started. So I have a order here. So Gabriella is the Vice President for Global Privacy at the Future of Privacy Forum. So if you want to go ahead and get started, please do.
Thank you so much. And thank you so much to Thomas Streinz for putting together a fabulous program in such a short period of time and on such a timely, essential, quintessential topic today. So technically, my background is in European Union's data protection law. I've studied it intensively since my last year of law school, about 14 years ago or so. And this is everything I did until today. And I want to continue doing that because it's a fascinating topic. So then imagine that very recently when I saw the Italian Data Protection Authority issuing a very reverberating order against OpenAI and blocking the use of ChatGPT in Italy on the grounds of the program, the computer program, having breached data protection law, I was among the very few people that were not surprised because I knew that data protection law and the GDPR are actually entirely applicable, fully relevant to all sorts of computer programs and technology that rely to a certain extent on personal data as input into whatever it is that they're doing, or that result in personal data as their output, so result into an inference about an individual that can be identifiable or so on. Because this is how data protection operates, but more importantly, this is why data protection was invented as a corpus of law many decades ago, with debates that started around the 60s and the 70s in parliaments in Western Europe and in the United States. And in the earlier presentation from Stein, he had a very interesting point in the beginning of the history of AI, when he said that in between the 40s and the 60s, there was an age of excitement related to computers. Everybody was wondering, what can we do with computers? Computers can eventually do everything. There was a fascination about computers, but there were also a lot of fears about computers. So what happened around the 60s is that a lot of debates started, particularly in Western European countries and in the United States, on what type of safeguards, what can we take from what we have in the existing law and legal frameworks to be useful in this new context of this almighty computer? Or is it the case that we need to come up with some new rules to create some new branch of law because what we have is not sufficient? And this is not something that happened overnight. There is a history of decades of debates that led to a set of principles, the Fair Information Practice principles that started this entire field of law. And some of my interesting research endeavors is actually looking at those initial years. And this is one of my favorite books in the world, a book from 1975, Emerging Data Protection in Europe, by this author named Hondius, who actually goes into detail and explains the type of debates that were taking place at that time. And he acknowledges that what he's writing in 1975 is going to be a piece of history in this field. And he knows that he will engage in a dialogue across decades because he understands that by creating a new corpus of law, in particular data protection law, that's only the very first stage in an evolution of this new corpus of law. There are many interesting things that he's saying there. But I want to go to one of the quotes where he says that one reason for the persistence of demands for new legislation on computers, because the computer, the almighty computer, was the concern in those decades, even in the absence of proven abuses, because at that time, the computers were not really as powerful as they are now, right? Was the scale of the medium and the irreversibility of the automation process. It was feared by many that if legal measures were not enacted at an early date, a future generation would have to pay the price for today's indifference. And this is what drove parliaments in the UK, in Sweden, in the Netherlands, in Germany, in Austria, in Belgium, in Luxembourg, in the United States Congress, to put together commissions and think about what should we do. They came up with this new corpus of law called data protection law, with some principles, some rules based on transparency about how the data is being used. They came up with rules about people having the right to ask for access of their own data, to ask for correction of data. In fact, the idea that people should have a right of accessing their own data and correcting their own data at a constitutional level protection came up in Austria in the very early 70s. And it's recorded here in this volume. So the fact that data protection GDPR is applicable to generative AI is not just a coincidence. And all of a sudden, oh my goodness, look, there's this law that is applicable to this very complex thing. It's actually intentional. And fair enough, the laws may be a bit old. No, they were thought about in the 70s. Then they evolved. Now we have the GDPR and everything that's inspired by it. And it marks evolutions. Maybe there's the case that we need to go to the next generation of data protection law that can tackle the evolution of this technology. But data protection law is very, very relevant, and it should be at the center of the current debates that we're having now. Well, I'll stop here.
Perfect. Thanks so much. Okay, so next up, we have Mark Rotenberg, the founder and president of the Center for AI and Digital Policy. Take it away.
Thank you very much. And I also want to thank Thomas for organizing this very timely conference. And I wanted to give a shout out, by the way. I see several people here who are graduates of our AI Policy Clinic program. It's nice to have you. And that's also, of course, an advertisement to the rest of you to find out what is that AI Policy Clinic program he just referred to. So you can go online and find out about that. We're providing a basic set of instruction at no cost for the emerging frameworks for the governance of AI. But I'm actually not going to say very much about AI policy on this panel. I think I'm supposed to do that on a later panel. I'm going to go back to my original domain, which was privacy and GDPR. We used to call it the EU Data Protection Directive for the older crowd. I started teaching privacy, by the way, as a law school class, and over time it felt more like a history course, and now it feels a bit like archaeology. So I'm not quite sure where to place US privacy law in the pantheon of emerging legal developments. But Gabriela, who's a dear colleague, and I think really one of the leaders in this field, she and I would agree that at least at the original inception, which let's say is the late 60s, early 70s, when societies first confronted the implications of the automated processing of personal data on privacy and civil liberties and freedoms generally, there was a surprising degree of convergence and agreement among democratic nations, certainly, about accountability, about fairness, and about transparency. A lot of this has evolved on the EU side over time. So you get a comprehensive approach in the run-up to 92 when you have the integration of the European member states and the European Union. You need a common standard to promote actually the free flow of trade, good, labor, capital. I think that's right. So there's an economic basis for the European data privacy law, and there's a human rights basis for the European data privacy law. Both of those were present in '92, and they're carried forward when the GDPR is adopted in 2016. Backstory, by the way, it's not clear that the GDPR would have been adopted, but for the Snowden revelations in 2013, which really turbocharged the privacy debate in the EU and moved forward that process. The story on the US side is a bit more complicated. We did quite well with regard to general privacy protection. We would say data protection today for the federal government back in 1974. We have a comprehensive law. But when it comes to the private sector, we go back and forth between sectoral legislation and some forms of self-regulation based on concepts of, privacy policies. So an original position that's common, divergence over time, and I would say quite remarkably in this moment, a growing awareness on both sides of the Atlantic that there is something new that requires a regulatory response. Now, not surprisingly, the EU is further along, and you already have on the table the AI Act. And the question when the generative AI news hits the world is kind of where do we, fit that in to the legislative framework that we're just about to finalize. Over on the US side, it's like, that's interesting. Maybe we need legislation. So you're kind of starting on the US side. There's a lot of interesting stuff happening in the agencies. You heard a bit in the earlier panel. And of course, you have the White House OSTP AI Bill of Rights. You've got some authorities at the EEOC and the FTC and elsewhere. Now, I'm going to say this about generative AI in particular, and then spend a few moments talking about our complaint to the Federal Trade Commission, because I promised not to talk about AI policy on this panel. I think the first thing to understand about regulating AI is that it clearly has roots in data protection and privacy broadly. And if you look at the essential structure of the EU AI Act, what you're seeking to do through this risk-based framework for the internal market is both protect fundamental rights and public safety. And that second category, public safety, tells you right away that we are somewhere adjacent to our traditional concerns about personal data. We're talking Internet of Things. We're talking about, network devices, of course. We're talking about a whole range in which we can automate processes that don't necessarily impact identifiable individuals. That's part of the EU legislation that stands apart from how we would traditionally talk about privacy. But there is clearly overlap, because when we get into decisions about people, we remain concerned about fairness, accountability, and transparency, which continue to be, really pillars of the AI policy debate. Now, generative AI, I would say, is fascinating in several respects, because we're talking, about the creation of new information, which can be drawn from personal data. So immediately you're thinking GDPR obligations of access and rectification, and by the way, deletion, because if you know the Google versus Spain decision, you know that the European courts have actually said that people have the right, so-called to be forgotten. We put that in air quotes. It's a little bit more complicated than that, but that's the basic principle. And those principles will continue to apply as we move forward with generative AI. But here's, to me, the really interesting court decision in the GDPR context in the past year that I want to share with you. And by the way, I enjoyed Stein's presentation this morning very much. I have a bit of a background in AI, by the way, because I used to do those rule-based expert systems. These were on kerosene-powered computers. We take big cans of kerosene and pour it into the back of the computer and run the crank. And after a while, you get some sparks, and eventually it would run decision trees and minimax optimization, alpha beta tree pruning. You know what I'm talking about. But as I said, that was the kerosene era. The cool thing, though, about rule-based expert systems is that you could prove outcomes. And if your chess program didn't quite understand how a knight moved and left it on the side of the board and kept losing games, you'd go back in and tweak that evaluation algorithm that Stein described and said, you know, actually centralizing a knight is generally speaking a good thing to do. And guess what? Your chess program got better. And we could figure all that stuff out because we could actually look at these decision trees and see the scores that were produced. You jump ahead into the machine learning world in a very famous match in 2018 when AlphaZero beat Stockfish, AlphaZero being a machine learning system and Stockfish being a traditional brute force system. And suddenly we don't know why moves are being created. It's like, oh my gosh, how'd that happen? It's really good. Who knew a king could move like that? But no one, including the former world champion, Garry Kasparov, could say why it was a good move. Now, the reason I'm mentioning that to you in this context, I probably need to wrap up, right? I do like to talk, but, you know, it's the law school thing. You guys know what I'm talking about, right? Because a lot of you here, either in law school, you've been through it. We all learn how to talk for a while until we're cut off. But what I was going to say, and this is the relevance, fascinating decision last summer from the High Court in the European Union. The Court of Justice of the European Union is asked to consider a surveillance program that gathers data from travelers. And the simple purpose of this program regarding the passenger name record directive is to try to identify who might be a threat to public safety, who might be a terrorist, okay? And the human rights organizations jump in and they say, you're looking through everybody's records. You have no particularized suspicion. It's just, you know, needle and haystack time. This is not what democratic governments are supposed to do. And so they challenge the PNR directive as being a form of mass surveillance. And the Court of Justice reaches this very interesting conclusion. It basically upholds the program through its interpretive authorities. It narrows it somewhat and imposes some additional safeguards. But this is what it says. It says because the decision-making system used in this context has pre-existing criteria that is reviewed by human operators, we will permit this kind of automated surveillance. However, it goes on to say explicitly, if this were a machine learning system that inferred, let's say, based on nationality or based on other factors extracted from the data set, a higher likelihood of a terrorist event, we would not permit it. And I think this case is very important for us to understand because it basically says those old-fashioned rule-based expert systems continue to be permissible for making decisions about people involving fundamental rights. But these new systems that are data-driven, that are inferential and produce outcomes that can't be proven, those will not be permissible. And if we really think through the implications of that decision, I think we could have a very interesting conversation about the application of the GDPR to AI. Now, I'd still love to tell you about my 46-page complaint to the FTC and how we are strategically trying to get these issues before the US government and how we also talked about the GDPR and anticipated what would happen in Italy, but that will have to come later. So thank you.
All right, thank you, Mark. Oh, go ahead. Thank you, Mark. Next up, we have Esha Bandari, who is the Deputy Director of the ACLU Speech, Privacy, and Technology Project and a co-instructor of the Technology Law and Policy Clinic here at NYU. Take it away.
Thank you very much. So I work at the ACLU. We are focused on the US and the US legal and policy environment. So, but pulling on some threads that have been mentioned, you know, I think what's noteworthy, and Mark alluded to this, the regulatory environment in the United States is very different than it currently is in Europe, both with respect to data protection, but also with respect to federal laws that would address automated decision systems. We have federal civil rights laws, regulating spaces such as hiring, that I think would apply to automated decision systems that are, involved in hiring decisions. But I would say the state of the law is quite nascent. So I'm going to just highlight, I think, a few issues, both from the privacy and the free expression side, that we're keeping an eye on with respect to generative AI. And these are just, potentially down the road issues. One, I think, the United States, again, an environment where there's the, comprehensive federal privacy law with respect to government data, but there is currently a fire hose of other data that's available to developers of generative AI and other automated tools. It's been collected from public sources. It's been collected through corporate surveillance, unchecked corporate surveillance in the absence of explicit laws prohibiting that. There's the data broker ecosystem. So I think a lot of the models that we see now are being trained in an environment of readily available data. And I'm not sure how much the developers of these models have taken into account the fact that this data may not always be available in the same form or with the same ease going forward. Obviously, the experts here on European regulation and developments in that direction, but also that in the United States environment, there is a movement for greater protection of data, particularly data collected by corporations from their users, and that this, what I'm calling the fire hose of data, may not exist. So what implications does that have for models that are trained with this? What errors or biases are going to be introduced in the future? And on the flip side of that, what pressures will there be to loosen certain data regulations because these models depend on them? So if you have industries, if you have governments that come to rely on certain models, certain AI tools, and those tools have a requirement or have been trained on certain data sets that are no longer available or are limited in some way, I think we will see pressures to loosen those regulations. So I think that's a dynamic we have to pay attention to. And related to that dynamic, my colleague Jay Stanley has just written a piece this last week about the threat of surveillance, increased surveillance that generative AI could engender. So, we already know that lots of information is collected, particularly government surveillance has access to this, wide set of data that's available in the United States, corporate surveillance also, but you could see collection of information in new contexts that is justified by the fact that AI analysis is so cheap. So for example, in a dystopian world, you could have employers collecting all kinds of data about employees, whether it's, emails, messages, conversations, all of it, which can be run through systems, and having the generative AI system, produce analyses, who's productive, who's not, who's likely to leave, who's not, who's dissatisfied and who's not. The cheaper such analysis becomes, and I want to say such perceived analysis, because I'm not making any judgment on, the legitimacy of these assessments, but the perceived ability to do this might justify increased surveillance in that context and in other contexts. So that's another thing that we're keeping an eye on. And then on the reverse side, I guess, I don't want to say the reverse side, but on the free expression side, not necessarily the privacy of data side, I think we'll also see with generative AI perhaps a push to regulate content that is produced by these systems, whether this comes from concerns around defamation or illegal content that is produced. There's obviously, a certain regulatory environment in the United States, which is limited by the First Amendment, but in countries around the world, which have less robust protections for free speech, you could see those moves where governments seek to regulate content or output on the grounds that it's not produced by a human. And I think you could also see some pressures to impose accountability on generative AI systems to remove anonymity, for example. So, the accountability of speech or content produced by a system, is validated by some human adopting that or someone taking ownership. And again, I think it's very preliminary, but the implications of this for the right to speak anonymously, which is a key cornerstone of freedom of expression. I think that's a concern and something to keep an eye on. And then, of course, there's also the potential for generative AI technology to simply eviscerate anonymity because it becomes very good at identifying who certain speakers and writers are. And again, as a fundamental human rights principle, anonymity has been, key to dissent and political speech, particularly online. So those are some developments that we're keeping an eye on. I'll leave it there.
Awesome, thank you. Okay, and then last up is Scott Laughlin, who is a partner at Hogan Lovells, where he co-leads the firm's global privacy and cybersecurity practice. Please take it away.
Excellent. And thank you so much, Thomas, for organizing this event and for letting me participate with my colleagues here. I think one thing that will quickly become apparent is that I think everybody else on the panel has spent a lot of time thinking about what should be the regulation of AI. And I spend very little time on that because my clients don't pay me for that. My clients pay me to figure out how can they use generative AI and how they can manage the risks relating to the uses of generative AI. And that's where I spend a lot of my time, is working with clients to not only figure out how they can responsibly develop AI and manage the risks relating to the ongoing commercialization of AI, but also importantly, how they can use AI that's generated by others. Kind of a separate set of considerations, also equally as important. I think one thing that, that characterizes kind of my views on this is, in some ways, this does not feel like my first rodeo doing this. I've had, many times during my career, looking back at it, where you see times where people will say the sky is falling with new areas of technology, or there's new sensationalist stories describing all of the bad things that are going to be happening with technology, whether that be the Internet of Things or cloud computing or mobile or social, right? The list is very, very long about when we've all gotten riled up and thinking about, well, do we have the right legal systems in place to be able to capture and to address these particular harms? And maybe for all of those, the jury is still out. In no ways, I think we're in a final place, but we have done pretty well in terms of trying to identify ways where harms are coming out of the uses of technology and being able to address those harms, whether that be through self-regulatory frameworks, whether it be specific regulation, legislation, what have you. All of those are at our disposal, and things that we should continue to learn from as we now think about, well, what is the ways of thinking about how to lawfully use AI on a go-forward basis. The other thing that I think that we should all be cognizant of is that when the GDPR was released, the United States lost its moral high ground in being able to regulate data. The United States is no longer a leader in being able to produce the thought that is instilled in legislation about how regulation should apply to data on a go-forward basis. That was encapsulated within the GDPR. The United States fell behind in that particular conversation. And the GDPR and like-minded set of laws then started to be replicated in a number of other regions. We're only now, and at the state level, in fact, kind of now trying to catch up with how the regulation of data is going to work. You see that with California and most recently in Iowa. We have 7 or so states, and we're going to probably have 8 or 9 by the time the year is done. And that's the way that it's slowly going to work. So if you think about that, that would mean that the Europeans have come up with a model of thinking comprehensively, right? Thinking proactively about how to manage data-related risks in connection with technology. That's not what we do here in the United States, right? We're reactive. We are trying to figure out where is the specific harm and where can I legislate to address that specific harm. Each of those models has benefits and has pluses and cons. I think importantly, if we are in the position where we are all allowing for the creative minds and the technology minds to be able to create the new types of technology that in the end will benefit all of us, that is the place where I think the US has placed its emphasis. And I think in many ways, the UK is also following that same pattern. And I think, of course, there's different models coming in within other regions. which kind of brings me back to my point about, well, what are organizations doing in light of all of this swirl, in light of all of the anticipated regulation, all of the potential harms that may come out of AI. And that is difficult. And I frankly think it's not at the moment at the corporate level being thought of as a data protection issue, although it is. It's being thought of as IP issues, trade secret issues, corporate confidentiality issues, and that is where the key issues are coming and where the focus is today. Because, right, generative AI, the thing that makes it different and unique compared to many other areas of AI that surrounds our daily lives is it communicates with us in a language that is easily understood. It's not that when you search Google, it's not using AI to depict search results. It is, right? It's not that when you are wearing your Apple Watch and you talk to Siri, that they're not using AI to be able to respond to you. It is. What's unique about generative AI is that it's speaking a language which makes you feel like it's a person on the other end of it. And that is unique and that is different. And that makes it so that when people are using generative AI in their corporate roles and within their functions, they are going to look for the easiest way to get to the solution. And that often is using generative AI because they can, no longer have to write their own press release, right? Which may take them 8 hours. Now they can spend 5 minutes saying, hey, can you write me a press release about this new technology? And you spit something out and you can hand it in as your own. Right? Students in the room probably over your entire lives have seen that type of dynamic play out and always have to think about, well, do I use this paper that's on the internet? Do I not use that paper on the internet? It's very similar in terms of those unique issues, which you are very familiar with and on the drives. And that type of incentive gets played out over and over and over again with a worldwide workforce. And if you can imagine how those organizations need to start to plan for their employees' uses of AI, that is really where I think the magic is. And that is really where we're thinking about, like, how do you come up with a framework that's going to allow individuals to harness the power of generative AI while not at the same time stifling the innovation that will naturally and be required to move that forward. And I think that's often going to, when we think about where that's going to play out worldwide, you're going to think about organizations coming up with a global approach to managing these issues, because it's not going to work if I just do the US or I just do Brazil or I just do China or I just do the EU. It's coming up with a framework that's going to allow me to deploy that nationally or globally. And then that is often going to be a principle-based approach, looking at all of the various principles that are inherent and at the heart of all of those proposed regulations. And that is where organizations will start to gravitate toward as they think about proactively managing their generative AI risks.
All right, perfect. So you all were fabulous panelists. We're great on time. I'm going to go ahead and use my kind of privilege here as a moderator. I have a couple of questions to kind of get us started with this discussion. So the kind of title of this panel is generative AI compatible with data privacy law? I think I mostly heard kind of like yes as the answers on this panel. So I'm going to ask just a couple of things that not that I necessarily have a strong view on it, but just to kind of like tease out this a little bit and figure out if there are kind of limitations to that yes or qualifications to that yes. So the first kind of thing that I'd invite all of you to talk about is, let's start with a specific example. So we mentioned the right to be forgotten. We mentioned the kind of idea of like data retention. What are these generative AI models trained on? These kinds of questions. So the right to be forgotten in the EU, or what I would think of as one kind of equivalent in the US, so the kind of ban the box movement in the US to protect potential employees or potential employment applicants from having to disclose past criminal history or anything like this. Do you see generative AI kind of blocking these kinds of concepts, blocking the right to be forgotten, blocking the ability to not disclose information? And do you see the EU and the US law kind of converging on similar sorts of regulations on how generative AI deals with this kind of information? Or do you see the two jurisdictions kind of diverging and dealing with these differently? And anyone's welcome to kind of comment on this.
I'm happy to start, and thank you so much for this question. It's one of the, let's say, paradoxes in this debate, together with the right to obtain correction of your personal data generated by generative AI and one of these computer programs. And I really don't like calling this right the right to be forgotten, because technically it's the right to obtain erasure of your data. It's not an absolute right, not even in the EU. So you can always balance it out. And also it depends on the technical possibility to obtain erasure as well. So we should not think of it in terms of this right being absolute. I think it remains compatible with generative AI and programs, computer programs like this, also because the GDPR has another obligation, which is the obligation to ensure data protection by design and by default in Article 25, which technically puts an obligation to whomever is developing these programs to think about how they have to comply with the rights of the data subject, including erasure, correction, and so forth, when they roll them out. And if they're not ready to be rolled out in a way that you can ensure these rights, which are part of the fundamental right to the protection of personal data as recognized by Article 8 of the EU Charter in the EU, then you should wait a bit until rolling them out. If you cannot ensure them. It's one of the core pillar, it's one of the pillars of the GDPR in that entire regime right now, this ability of embedding ways into your technology that ensure respecting this individual rights. Now, if that's impossible to do, let's wait a bit and see how smart these machines can be in such a way that they can actually be able to do this ultimately. So that would be my answer.
Thank you. Anyone else?
Sure. I'll jump in with a couple quick points. First of all, when there's this collision between an emerging technology and a legal regime, because I went to law school, not engineering school, I think in terms of compliance. And so if the emerging technology cannot comply with the legal regime, you actually don't release it as a product. I mean, you can continue to research and maybe you come up with a better, safer way, which is frankly the evolution of most of the modern regulatory state, is to make products safer for people. So personally, I think that's a good thing. I think that promotes innovation, but fundamentally it's a compliance issue. The second point to make, and where I think the real collision is between generative AI and machine learning generally and privacy, is actually not the right to erasure. It's the principle of data minimization. And data minimization is deeply embedded throughout privacy law. Even the US state attorney generals, who don't have a whole lot of background in privacy law, have gravitated or data minimization when they confront a whole host of issues, from identity theft and spoofing and on it goes. And I think there are ways to solve this if the people in the AI community take it seriously. And to be clear, by the way, we're talking about data minimization for personal data. If you're doing climate change, whatever you can gather, go for it. No one's going to stop you. But if you're collecting data about people, that's problematic. And I think machine learning, the world of machine learning needs to kind of get beyond some of the slogans. I mean, they're very smart people like Judea Pearl who have said, let's think seriously about AI models that aren't based on the maximization of data collection. So, and also, by the way, thank you for asking me about the FTC complaint, because I really did want to get to that. I'm glad you raised it. So this was going to be my third point, but it'll be brief. And I think it kind of ties together a few threads, because what we needed in the US was a strategy to put some of these issues before US regulators. And we don't have the privacy framework like the GDPR to be able to say to lawmakers on the US side, well, how does this line up with, Article 25, for example? But I do know quite a bit about the FTC's authority. And if I may say, I actually brought the two cases to the Federal Trade Commission in 2009 against Google and Facebook, that led to the commission's settlements with those two companies. You might have heard of them, by the way, internet startups, so Facebook, Google, 2011, and gave them the FTC 20 years of authority over those two companies. They were reluctant to exercise that authority and actually had to sue the FTC, but that's a story for over drinks. Returning to the topic of this panel, we basically went to the FTC in March and said, without saying GDPR, you FTC have already said what good business practices should be for companies offering AI products. You've said this in a number of statements. We have looked at OpenAI. We have found the pricing chart by token on their website. This is a product for sale in the United States. You have authority here, and they are not transparent. The outcomes are not provable. They're not fair, and they're not accountable. You need to act. So that's the essential way on the US side. We try to get this business product into the realm of some regulatory oversight. Thanks again for asking.
Excellent, of course.
So I'm happy to, I mean, I totally think that they're compatible. And I frankly think that we've been doing this for a long time and just don't talk about it because, before AI was a big thing in the general space, AI has always been big in healthcare in particular, as we look for correlations between different types of disease and underlying health conditions or every type of treatments and those things. That's been what we've been doing for a long time. In fact, AI is just really an extension of the human brain where we try to start to have that stuff in our brain and then come up with the solutions. Now we are having computers do that faster and at a larger scale. But in healthcare, right, we have our HIPAA, which has been a healthcare set of rules and regulations that we've had for a long time. And some of those things require data minimization. It requires us to have any type of business associate, which is kind of like a processor in the GDPR world. They need to return or destroy all data at the conclusion of the agreement with the covered entity, right? So there's an erasure. It's not an individual right. It's a business-to-business relationship. But I've counseled many companies in of business associates who have developed complicated, very sophisticated AI-driven software that's designed to be fed with healthcare data, where we're very much working through data minimization principles and creating the structure so that individual data sets can be removed without undermining the ability for the product to continue to run. So the challenge around data erasure, right, to me, is a situation where it's like you're building a car and you have to realize that you're building it in a way to comply with the speed limit. You're building something that has to be able to account for outside principles. It's not that the car doesn't work. It's not that the AI doesn't work. It just needs to be built in a way to anticipate what these requirements will require.
Maybe the only thing I'd add is it's not that I see these as incompatible, but I would caution us to see the limits of, for example, an access to data, right, and solving the problems that are raised by generative AI. So in the United States, we have, in the context of credit reports, for example, people can see, what underlying factors are on their credit report, seek to correct it. And, you've got pretty basic algorithms that, you might say it's a closed universe taking into account certain factors. When you're talking about generative AI, I think and other forms of AI, I think the risk is you've got essentially outcomes that are not explainable by any person or any set of factors. So even if you added in, a requirement to say, purveyor of this generative AI tool, show me what information you have on me that was used to make a hiring or housing decision. I don't know that seeing that data alone is going to tell you whether there was some bias or impermissible factor that crept in. And so I think that's where our regulation might have to adapt to account for that.
Awesome. So let me go ahead and ask just one more quick question. So again, kind of on this theme of pushing back against the answer to this question might be yes. So a couple of you said things like Europe is ahead of the US in terms of regulating privacy, certainly. And in my mind, one of the big debates in the kind of academic privacy law scholarship is whether the kind of European sort of general approach, kind of regulating all kinds of data versus the US sectoral approach of regulating particular industries, which of these is more effective? And the huge literature spanning 20, 30 years now, kind of debating this question. So one thing that strikes me reading the AI Act, for example, is the kind of like tier system that the EU has kind of introduced here. There's high risk AI, like in biomedical or medical situations, criminal context, employment context, things like this. Lower risk AI that demands less kind of regulation. This to me reads almost like something like the sectoral US approach. We're going to regulate health, we're going to regulate education, as these are highly sensitive areas. So in your mind, is the kind of traditional debate of the EU approach of regulate everything with a kind of general regulation versus this US sectoral one, is that still accurate? Is that still the kind of right way to think about this? Or do you think that there are lessons from the kind of US approach and what the EU is doing now? Or am I totally off base with this question? Anyone, feel free to chime in.
As we're aiming to be the ideal panelists, right? We'll go again in this order. So let me start by saying that perhaps surprisingly, or perhaps not surprisingly at all, there has always been in this particular field on how to regulate computers and data and things that would affect individual rights, and so forth. There has always been a very, very interesting dialogue. The most interesting dialogue in the space happened between Europe and the United States. And this goes back to these laws in the 60s and 70s that I like to talk about a lot. And in fact, even in this book, our friend Hondius writes that whatever was happening in Europe in terms of parliaments coming with principles about how we should use, process personal data, it happened in the US at an earlier stage and even in a more intense way. So there has always been this type of back and forth between ideas on how to do public policy and how to legislate in this space. And I'm not at all surprised that now the EU, after having done the general approach on data protection law, now the EU has been looking at the US and what was happening here and is trying to sort of split that into some level of verticals. And I have been hearing debates in Brussels on whether there should be rules out there dedicated to very specific fields and areas. And one example in this case, and I don't think necessarily the UAI Act and the risk-based approach is the immediate example, but one other example is a directive that was proposed as part of the EU data strategy package that particularly looks at the rights of workers in the gig economy and has a lot of rules about algorithmic decision-making in that space. And that's a proposal for the time being, it's being legislated, but it's one of the examples of the EU now rethinking a bit its approach. I'm not sure if for the better or for the worse, to be honest, but it's happening, so it's not surprising. Very good point.
It's an interesting example. So I'm not sure what to say about this question. I wasn't actually aware that there was much of a debate in the academic literature as to whether the US approach or the EU approach made more sense, at least in the privacy realm. And I say that simply because even on the US side, it's just an utter mess. I mean, the sectoral patchwork, I think we used to call it like 20 years ago, is now just, tattered threads. There's not a whole lot there, but that's not to say that the GDPR is beyond criticism. And certainly over the last few years, there's been increasing focus on a structural problem within the GDPR, which is the coordinated enforcement action of the various national data protection agencies. And so you have, a lot of firms that are based in Ireland that appear to get a pass from the Irish DPA. You have the Germans and others who are very upset about this. You have a referee at the European Data Protection Board who's supposed to coordinate these activities. And I think most people look at this and say this is not working particularly well. So I've got criticisms for both sides, but they're different. And on the US side, frankly, not only are we lacking adequate privacy protection in law, on the US side, we're actually lacking an adequate conception of privacy, because we still talk in terms of this notice and choice regime as if there are market-based solutions, which is frankly descriptively absurd, because most of the internet economy is a two-sided market. You don't even participate in the transactions that involve the commercialization of your data for internet advertisers. So even to impose market-style approach to the online economy, frankly, makes no logical sense. But here's the last point where I think we can learn something, at least on the EU side. What you see in the evolution from the GDPR to the EU AI Act is greater focus on this problem of coordination of enforcement action. Because if you see this as a weakness in the GDPR, you don't want to replicate it in the next legislation. And that's why the coordination mechanism actually becomes much more important in the context of the EU AI Act.
Excellent. Anything to add?
Sure, a couple of things. The first is, I mean, I think it's obvious, but just worth noting, right? The GDPR, all of the sectoral laws, these are human creations, and humans are messy. Humans don't agree. And if I asked all of the DPAs in Europe for what the definition of personal data is, they may give me 28 different answers. If I ask them how to define anonymized data, I'm pretty sure none of them would define it the exact same way. That comes up in the context, right, to Mark's point around in the enforcement. We feel like there's places where in Ireland or the UK or the ICO, we're not going to have the type of regulation or the type of way that they're going to apply the GDPR than you would have in front of the CNIL or from in Spain or in Italy. So all of that is going to be the case because people have different value judgments that they're applying to this information. And the more sensitive that information is, the more likely is that they're pulling from personal experiences and applying that to with how they view individual data elements. And so that I think will always be, and I frankly think it's going to be replicated because no one's going to know the definition of AI. Forget if the gentleman over there had mentioned that during the prior panel, was that there's trying to define AI is a real difficult thing to do. And, you know, it can be anything from the spell check that's in Microsoft Word, you know, to a driverless car, right? It's all of the things that are in the middle, and trying to regulate all of those things right in the middle in the same way is a difficult thing. And that's where I think you start feeling like there's that tier system that's going to be put in place to give that flexibility. While I am totally would expect that that flexibility is going to be one that's going to be rigorously viewed and scrutinized as people deploy it. The other thing I'd mention, just because I don't want it to be lost here, is that we are very focused on AI and personal data. I think if you were to ask most organizations who are really deep in the space, they don't think that personal data is that important. In fact, the shelf life on personal data is very small. So having the ability of not using it for very long is actually something that most people would be okay with. It's going to be the learning, right? The correlational value between attribute 1 and attribute 2. That's the most important thing. And so they can create that with synthetic data or phenotype data or any of the other data that are not actually related to individuals, but are inferred or created through looking at individual behavior and mass.
Okay, perfect. Okay, so I think we have time for a couple of audience questions at least. So raise your hands. I assume someone will come around. Thomas, maybe with a mic.
Hi, Lori Fina. I did have a question about the intersection of personal data and contextual augmentation. So most of these AI models are built on very large training sets, and we've talked a lot about training sets, but a lot of the real answers are going to come from contextually injecting information either from companies or individuals to get an answer about your data and your situation. And so a lot of the questions are going to come up when people want that personalized medicine or AI advice about their financial situation or scoring for hiring or other kinds of redlining capabilities that AI is usually applied for. What are your thoughts about that? And how do you create fences around individual data, not just right to be forgotten, but right to fence off and not have it continue to move through the system?
I think this is a more appropriate questions to for engineers, I suppose, and for people that are actually building the systems, to the extent that they would talk to Scott and to me and to Mark and would allow the data policy, data protection world to give them useful input. Frankly, I don't know how that would be done in practice because I'm just not a computer scientist. Maybe Mark.
Too hard.
I mean, it's a tough question. I think it is trying to have folks anticipate when they're developing AI, how it can be used either intentionally or unintentionally. It's kind of, I remember a client several years ago, I was talking with their CISO and they made a connected pacemaker. And I said, well, how have you thought about the security of that device so that people couldn't hack into it? He said, well, why would anyone ever want to hack into it? And so you'd be surprised that, the mischief that people like to do, right? It's trying to anticipate how those technologies will work and then trying to be proactively about thinking about how to address those risks. It's not going to be perfect. There's going to be a lot of egg all over the floor and there's going to be a lot of stories that are going to catch your breath. But over time, my guess is we'll figure it out.
The only thing I'd add to that is I think one of the regulatory approaches is to permit data collection for specific purposes and then require deletion. And I think that's often, maybe it's lost somewhat because the idea is like, what can you collect or what can you not? But a lot of the contextual issues might arise where data is collected for one very specific, perhaps legitimate purpose. Then it's kept for years and years. And then there's new technology or capabilities that combine with, a long held data set that provide context that might trouble us. And so I think an approach that applies here is either, data minimization in the sense that you collect for one reason. And then it's not just that you're limited in what you can use that data for, you just don't retain it. And I think that's maybe anathema to a lot of practices in the United States right now.
So I see a bunch more hands. Thomas, I'll leave it to you to.
Yeah, let's take one, maybe two at a time, and then we'll have to.
Perfect.
Hi, I'm Natalia Levina. I'm a professor of technology from the Stern Business School. And so I wouldn't be surprised by the context of my questions. It's probably my first law conference, so I'm fascinated. But a couple of things you said collectively resonated with me. One, and I'm going to phrase several questions in this way. What have we learned from regulating cloud that could be applied? Because I also, through my career, lived through these waves that Scott, you mentioned, like one after the other. And at least now teaching and researching AI, some of it is similar to what we encountered with cloud when, for example, individual users in business would be using cloud services that were not sanctioned by corporations. And we eventually figured out they were storing confidential proprietary data there. Related to that, I heard you say that, well, the fact that it's a product makes it potentially feasible to regulate, but because OpenAI can charge prices. What would it mean if we have more open source tools? Because I believe this law school has done quite a bit on open source regulation. And finally, related to that is sort of what about global? Because if we start regulating even in Europe and US, some of this building of these generative models could be done somewhere else. And are we really losing or winning in that global competition? So 3 business related questions.
Well, so let's grab this last set of questions and then the whole panel can answer all of them. Go ahead.
Thank you so much. And thank you for this vast variety of perspectives, very enriching. I might take a sort of high level perspective. We've talked about national level, regulation, state level and regional, but as you'll be aware, the UN is currently in this process of looking into a global digital compact. And coincidentally today, they're discussing data protection. So I'd be keen to hear perspectives on what the usefulness of that might be, what could it look like, and what risks or challenges you foresee? I mean, not so much perhaps in geopolitical perspectives, but more in the technical side. Thank you.
Go ahead.
Well, I was going to jump in, first of all, on your last point. So I promise not to talk about AI policy frameworks on this panel. But if you stay around for the subsequent panel, we'll talk about the UN, UNESCO, the EU AI Act, G7, G20. There's a lot happening on the global level. To your question, I actually thought Scott was going to get into this earlier, and since he didn't, I just wanted to share with you the concern I would have advising businesses about generative AI is that this product is basically an information sponge. Because what generative AI does is train on the data that the company provides so that you can model a press release in the style of your firm, a consumer response, a client contract. I mean, on one level, very useful to be certain, and companies all across the country are experimenting. But the other thing you really need to consider is that the legal obligation of partitioning, which has been there forever and ever, really gets tested in the generative AI model. Because for the company providing the service, there is to be certain value that's obtained when similar firms that have provided data, that data is joined. And I am just very intrigued, frankly, it's not my space, but I am very intrigued, and I've been in meetings with general counsels of companies, and we actually discussed this on our FTC complaint, because Samsung found its proprietary, project documents available to its competitors because someone had tried to use GPT as part of an internal presentation, and boom, right? So it's, I just think, a fascinating issue. I'm kind of curious if Scott has encountered it.
All the time. I mean, that's when I said, like, I think the driver is IP and confidentiality, because that's where people are most concerned about, is the Samsung situation. And this is going to be a moment where we are going to be kind of wrestling with this issue, where people will use and consume technology without understanding how it works. And they'll bring their predetermined or predispositions to understanding how technology works and think that the technology works the same way. So in all likelihood, I would fully expect that people are going to think of ChatGPT in the same way they think of Google, or they think of Yahoo, or they think of a search engine. And they're going to be providing information into that, expecting that that information is used by, Google in its capacity as, as just the, I don't know, the benign overlord of the internet. It is not a situation, as you said, right, that you can expect that ChatGPT or any of the other types of generative AIs are going to adhere to those same principles. And as a result, you need to have people understand that this is a technology that can be used in specific contexts, but not in others, right? I kind of try to think of it like you can, don't think of a generative AI in the same way you think of Google. Think of it as, the smart person at the end of the street who you go and he'll give you really good answers to whatever questions you have. But the next person that comes there may get a question that is informed by the one that you provided. An example could also be for clients who have corporate development. If you have 4 or 5 people within your corporate development who are searching a potential acquisition target, and I say, hey, I'm interested in this company in this particular area, ChatGPT is learning from that. And somebody across the entire world could be saying, hey, is it good for me to invest in that target? And the answer could be, yes, we're actually seeing a lot of interest from corporate development companies on the other side of the world, right? That is the kind of thing where if you think that you're interacting in a way with an anonymous way, that you can get in trouble with how you use generative AI. And if you're not understanding that it's distinct from how a search engine works.
I might address a couple of your questions in particular, and I'll start with what about global? Well, you might be surprised that, in fact, the first dedicated generative AI draft of a bill was actually published by China last week. We have Brazil which has been working for a general purpose AI law for about 2 years now, and they have made important steps to advance on top of their very GDPR-like data protection law, which is the LGPD, adopted a couple of years back. We have an initiative in South Korea that has been going on for a while, again, on regulating AI. So there are regulatory movements. Similarly, with the EU AI Act being perhaps the most debated and the most advanced, but they happen everywhere. And all of this comes on top of the general data protection laws that most of these jurisdictions have adopted. Then on the what have we learned from regulating cloud computing, we have learned a lot because data protection law, the thing we're talking about now in the GDPR particularly, they are technology neutral. Doesn't matter if you have an IoT device, if you have a cloud and what type of cloud, if you have AI, whatever technology you have, if it touches personal information in a way or another, this law applies to it. The problem is that data protection law is a Cinderella of the legal education system, I would say. And I would urge our colleagues at NYU Law to follow Thomas's lead and consider this as a key area of law that needs resources and thought and study, because it's very relevant. So I'll stop here.
All right, so we are just about at an hour, so we'll end it there. Thank you all so much for joining us here today. This is fabulous.